Good afternoon. My name is Adam Blaylock. I'm a counsel attorney here at Miller Johnson as part of our education group. And over the past couple of days, we've started fielding a number of questions related to communications from the U.S. Department of Education regarding their request for certification. So today we'll give a brief update relative to the facts that have led to this particular request, and then a little bit of information for our education clients to know about this act. Back on February 14th, 2025, the U.S. Department of Education issued a Dear Colleague letter applying Students for Fair Admissions versus Harvard, a college admissions decision, to the school district context. And ultimately, it did so in order to reinterpret Title VI, which prohibits race discrimination in our schools across the country. A couple of weeks later, the U.S. Department of Education also issued an FAQ summarizing some of its findings in that Dear Colleague letter. And it stated, in pertinent part, that schools may not discriminate on the basis of race, color, or national origin in their programs or activities. Importantly, though, it also says, many schools have advanced discriminatory policies and practices under the banner of DEI initiatives. Other schools have sought to veil discriminatory policies with terms like social emotional learning or culturally responsive teaching. Then, last week, we saw that the U.S. Department of Education issued this notice to state education agencies like the Michigan Department of Education and requested certification that both local as well as the state school agencies or education agencies are complying with Title VI. In this notice, it importantly notes that each state education agency is required to file a single set of assurances, and that those assurances include its commitment to comply with all of the federal statutes. And it also imposes the obligation for those state education agencies to gather that information from locals, like the school districts that we support across the state. As part of that guidance, the U.S. Department of Education stated that the continued use of DEI practices may subject the individual or entity using those practices to serious consequences, including the termination of or refusal to grant or continue financial assistance, potential initiation of litigation for breach of contract by the Department of Justice, or potential liability for claims for money when an entity is not in compliance that may subject the entity to liability under the False Claims Act. What I'll note as part of this is that this request for certification reinterprets Title VI, which we have been complying with for decades, very differently than prior administrations, including the first Trump administration. So I do want to give a slight overview of this topic of the False Claims Act, because I think it's potentially the most important part of this new guidance. The False Claims Act is a broad federal statute that prohibits entities and organizations and individuals from making false claims to the government. So it prohibits the knowing submission of a false claim to the government. It also authorizes a type of lawsuit called qui tam, which allows for a private party, an individual, to sue for enforcement on behalf of the federal government. And then critically, it also includes these extreme damages provisions. So what it does is it allows for treble damages. That means the tripling of any damage that's incurred. It shifts attorney's fees to the prevailing plaintiff. And then it also imposes civil penalties. So what does all of this mean right now? First, nothing just yet. At the time that this presentation was recorded, MDE hasn't taken any position on this stuff yet. What I do know is that the state of New York has already come out and opposed this certification requirement and said that no such certification will be forthcoming. It's entirely possible that the Michigan Department of Education takes a similar tack with the Trump administration. But we do have to remember that MDE is currently charged with gathering these certifications from local education agencies. And so we'll need to reckon with that over time. Next, and this is also really critically important in dealing with this, school districts have already certified compliance under Title VI. This new interpretation is broader and appears to invite those qui tam actions. So in terms of immediate recommendations, there are just a couple of brief takeaways that I have for you today. First, take a look at your hiring, training, and curricular practices for compliance. I know that we do lots of things to take care of our students, but it doesn't hurt right now to spend a little extra time to look at those things and make sure that we're being compliant and that we aren't discriminating based on race. Next, I'd also suggest reviewing your insurance coverage relative to potential false claims actions by either the Department of Justice or a key Tom plaintiff. And then finally, take a look for guidance from MDE related to these certification practices. On behalf of the Miller Johnson team, I just want to say thank you for taking a few minutes to listen to these important topics. Ultimately, what this comes down to is making sure that we take care of our students and we do so in a way that's compliant with the law. So take this time now, before it's a problem, to impose a little preventative maintenance and make sure that we take care of the things that we need to take care of so that we can make sure that we educate our kids to the best of our ability.